Okay, thank you very much. Good afternoon to everyone. Thanks, Igor and Susana, to invite me. It's a pleasure to be here in this event. I would like to apologize in advance if my English is not good, but I will try to do my best. So the title of the project of my thesis is a provisional title, Navigating Autonomy Liability Issues in the Maritime Law with the Advent of MAS. This is the table of contents. I'm going to explain the state of the art, the objectives, hypotheses, methodology, and conclusions. So let's begin with the state of the art. Liability in the maritime sector has historically been based mainly on human errors or human decisions. But now we are moving towards an increasingly automated environment. So the probability to have accidents caused by human errors will go down, while technological errors will be more relevant. In the context of unmanned ships, the first question that arises is how the duties and responsibilities that traditionally assigned to the shipmaster can be fulfilled when there is no physically presence on board. To understand how these duties can be fulfilled or performed, in my opinion, the first step is to study all the usual responsibilities that a shipmaster has in a conventional or cruise ship, and then study how and by whom they could be handled in an autonomous system. As for the RCC workers, the remote control center workers, the question that arises is, can someone who has only trained with simulators be considered a good seafarer? It will be responsible or can be the ship owner be liability or has liability for in eligendo. And as for the AI, can an AI system keep or maintain a proper lookout? If AI makes a mistake, who will be responsible for that mistake? Who is responsible for the actions and decisions of a software or an artificial intelligence system? The ship owner, the developer of the software, the shipyard, we will see. And how can this liability be proven? So my research focuses on unmanned ships, particularly in the changes that new technologies will bring in terms of liability, and specifically in the possible redistribution of the traditional responsibilities between the new key actors: the remote control center, the remote master, the shipyard, the repair yard, the ship owner, and the developer of the software, and the maritime carrier. Objectives. The main objective of my research, as I said, is to analyze how new technologies are going to change the maritime rules, the liability rules in maritime law. And I will focus on study how to identify the legal challenges in this area. These objectives are to define and outline the emerging responsibilities for key actors, to analyze whether the LLMC and its protocol needs to be amended to apply to MAS, and if the limitation of liability will be extended to new actors, to investigate the impact of the new 2024 European Directive on product liability in the maritime industry, especially on MAS, because MAS ships has software, and the directive, the European Directive now says that a product, the software is a product, and to propose legal and practical solutions that facilitate the adaptation of the current legal framework to the new technological reality. Hypothesis. As Professor Filippo Lorenzo said the other day, it's not impossible, but it will take time to see IMO degree 4 vessels. It's more likely, as requested by the CMI working group, that we will see degree 3 vessels. So it's probably that IMO will change the classification of autonomy in the non-mandatory MAS code of 2025, and MAS won't be able to operate without human supervision. Mass will be comparable in terms of safety to conventional vessels, but not comparable in terms of liability. The remote master will be equivalent to the ship master, but will have new functions, and other RCC workers will not be considered seafarers unless the RCC is located on another vessel, because the RCC can be on land or in another vessel. The RCC could be held liable in case of a collision. A single vessel could be controlled by multiple RCCs during its journey, and there could be multiple remote masters for the same vessel during a single journey. The limitation of liability and the Himalaya clause, as Professor Martinez told about us, will be extended to cover the new actors. And the international legal framework are not prepared to include all the potential parties related to a mass. A ship could be considered a product, and I know this is a controversial topic. We saw it a few days ago here. But I agree with Professor Mudrik and also with Professor Ulfbeck from the Copenhagen University. If you see the directive, the European directive, the term product refers to all movable property, regardless if it's interconnected, or if it's interconnected with movable or unmovable property. So at least in Spain, a ship is a movable property, even if it's a movable property sui generis. So for me, or in my opinion, it can fit in this definition. Software embedded in a mass shall be considered as a component in the European Union, and the developer of that software could be liable for defective products in Europe, but the same software developer might not be able in other countries with different rules. A substantial modification to the software could make the ship owner liable. The shipyard won't be liable for the defective products, even though it introduced to the market, as the directive said, because in any case, the ship owner is responsible for the vessel's seaworthiness. The role of the shipmaster, as traditionally convinced, will change significantly in the context of mass. The remote master will take on the captain's or pilot's role, even if it's not physically on board. Many maritime conventions that impose duties on the shipmaster will be modified. About my methodology, I am using doctrinal legal research, comparative analysis, and law and technology. And the conclusions are: the arrival of the mass will considerably change maritime liability. The traditional way of assigning responsibility, which mostly depended on human actions, will need to be rethought because of the new roles of artificial intelligence, remote operators, and other important people involved. It is clear that the current legal framework is not ready to handle the complexities of mass. The IMO needs to act quickly to create a complete mass code and an international mass convention to make sure these ships are properly regulated. If the law doesn't respond quickly, the maritime industry may face problems with unclear rules about liability. And in conclusion, the evolution of autonomous ships demands urgent legal reforms, and it is crucial that international maritime law evolves to ensure safety, fairness, and clarity in this new area, or in this new technological area. Thank you.